I came to learn that my father was actually a chief. And as a chief, I would accompany him sometime to go under the tree of men, which Madam Sosa was referring to listen to my dad arbitrate over disputes in the community. And I dare say, my dad has even arbitrated over murder cases. And I'm saying that intentionally because the reality on the ground is that if a community member, whether in Karamoja land, in Toposa land, in Turkana land, in the land of the Jie, the land of the Nyangatom, if they have a problem with their neighbor, the first point of call for justice is the council of elders or the neighbors or Nyumba Kumi or the chiefs, as I saw with my dad. In fact, I don't know of anybody in my village who has ever sued anybody in the formal judicial system. Yet, after what I saw with my dad, arbitrating over disputes under a tree, that inspired me to go to law school. So I went to law school, interacted with a very formal legal system. In law school, we were taught about people called Lord Denning, who was a great Justice of the House of Lords in England. Lord Magnatan, Lord Atkin. Every time I read about Lord Denning, I can actually compare Lord Denning to my great-great-grandfather. But the system was so rigged against my people that if the Council of Elders of the Turkana people arbitrated over a dispute, and one of the people in the dispute is not happy with the outcome, they actually go to court and the case begins as elders. Being favored, whichever person favored it, to the detriment of the indigenous peoples who occupy this part of the planet. Despite the fact that 99% of their disputes are being done at the community level, the formal judicial system in the country, and the story in Kenya is the story in Uganda, in South Sudan, in Ethiopia. The formal system has been structured in such a way that it disenfranchises those of our people who are indigenous, who cannot read and write. So that if you went to court today, and I'm speaking as a practicing advocate, I have seen people struggling with the law. You go to court, there's an old man arrested over some stock theft issue. They have brought to court. They have no idea why this gentleman called PJ Otieno is called my lord, as if he's a god. No idea on the basics. Every time he or she hears a lawyer saying my lord, they remember the last time they had my lord was from some crusade. That injustice is real in this part of the world. There is a big distance between the people and the law. And that is why the theme for this particular edition of the East Africa Legal Empowerment Summit is about human rights. Even before we talk about human rights, what human rights ni nini? in my legal practice, every time I meet my clients in the office, I find that people who are very distant with the law. Sheria iko pale na watu wako pale. Now, I ask myself, if the vast majority of the people don't understand this foreign thing called the law, you know, the modern law, the statutory law, sheria inafaa kuwahudumia, hawaelewi sheria at all. The law is authored in a foreign language, sometimes in beautiful Latin language, and that is left to myself and Honorable Ekweviro, Dr. Kuru Aukot, Professor P.L.O. Lumumba, P.J. Otieno, all the lawyers in the room, to the detriment of the people who are the vast majority. So as I welcome you to the first edition of the East Africa Legal Empowerment Summit, I would like to urge you, the way I urged myself, to think about whether this democracy we are talking about in this part of the world, whether this access to justice we are talking about in this part of the world, whether these human rights we are talking about in this part of the world is actually serving the people who are the vast majority. And that is the bottom line of this particular summit. So I take this chance on behalf of the Board of Trustees of Article 43 International, led by the very able, my learned senior, Dr. Kuru Aukot, to welcome you to the first edition of the East Africa Legal Empowerment Summit. Na tumeweka mkutano huu, itakuwa mkutano wa kila mwaka. Na tutakuwa tuna rotate. Siku moja tuende Samburu County, siku nyingine tuende Moroto, siku nyingine tuende Ethiopia, tuende South Sudan, tuende Uganda, na tuende sehemu zingine za Kenya. We want to take legal education to the people. And that is why, as Article 43 International, our key thematic area is grassroots legal empowerment. We want to dedicate, as a way of giving back to this community, we want to dedicate our lives as legal professionals to enlightening the people of this region, ili na wao pia wawe kama wa Kenya wengine, Waganda wengine, wa South Sudanese wengine, au wa Ethiopia wengine. So, law. Can we, for instance, if you ask me, looking at the budget of the judiciary, if you ask me, 90% of the budget of the judiciary, apart from that which ought to go to emoluments, should be invested in alternative justice systems. Operating without a budget, but handling thousands of cases on a day-to-day basis in the forgotten corners of our planet. So as you think about that, as you philosophize around the subject of legal empowerment, I want you to ask yourself this question, which I have asked myself. Hii sheria kama haieleweki na watu wengi, hii sheria inahudumia nani? Can we strengthen our traditional justice systems? By the way, the Constitution of Kenya 2010 recognizes the traditional way of doing things, including the traditional way of justice, provided the same is not repugnant to morality and justice. So that based on that particular prescription of the law, can we go back and take the law to the people? I'm trying to imagine a Turkana guy who woke up in the morning today, akapeleka mbuzi yake malishoni kule Kapedo. Okay? That guy has no idea what is happening in Lokichar, leave alone Lodwar, the HQ of the county. Okay? How can the law be structured in such a way that we take this legal knowledge to the people? Not that they become lawyers, because not all of us will become lawyers, but at least the best antidote against bad governance is an enlightened citizenry. So they will know, have a line of speakers we've prepared to take care of you in this time. Asanteni sana, Mungu awabariki.
Thank you so much, Ekai. We didn't get a chance to read the Ekai Nabenyo's bio, but Ekai is an advocate of the High Court of Kenya. He is a social change maker, a human rights advocate whose work spans law, governance, and community empowerment. He is the founder and executive director of Article 43 International, an organization advancing socio-economic rights and legal empowerment for underserved communities. Nabenyo also currently serves as the director of legal affairs of the county government of Turkana, as well as managing partner at Nabenyo and Company Advocates. Ekai holds a Masters of Law in Migration and Refugee Law from the University of Dar es Salaam, where he graduated with this distinction and was recognized as the best overall student. He is also a holder of the Bachelor Law degree from the University of Nairobi, a postgraduate diploma Law from the Kenya School of Law, and has undertaken leadership training at the University of Cambridge. His career reflects a deep commitment to justice and inclusive development. He has represented communities and policy interests at high-level forums. High-level climate change conferences, COP1 in Paris, and Convention on Biological Diversity in Cancun, Mexico, the C40 World Mayors Summit in Copenhagen, and several regional and global human rights platforms. Research and writings on migration and refugee rights the First Migration Review and featured in outlets including The Guardian, RFI, and the Nation Media. His voice has amplified concerns of marginalized communities, particularly in Turkana, on global stages. He is the recipient of several prestigious recognitions, being named Queen's Young Leader by Her Majesty Queen Elizabeth II in 2016. A top 100 most influential young Kenyan 2018, and a spark international change maker at heart. Ekai is dedicated to becomes a tool for dignity, equity, and empowerment. Through his leadership, he continues to champion access to justice, protection of human rights, and inclusive governance across the region. And that is Nabenyo, the director of LESS, the convener of this summit. Ladies and gentlemen, at this point in time, permit me then to welcome Dr. Ekuru Aukot. And Dr. Ekuru Aukot, as he comes, Dr. Ekuru Aukot is an advocate of the High Court of Kenya. He is a distinguished constitutional lawyer and an accomplished legal scholar. He is the founder of EL Law, a firm providing strategic legal and policy advisory services across Africa. He is widely recognized for his pivotal role as a member of the Committee of Experts on the Constitution of Kenya, the body mandated to draft and deliver Kenya's transformative design, governance, and School of Law as a refugee Nairobi, full of refugees strategies, humanitarian affairs. Regionally and internationally, Dr. Aukot, legal and policy advisor in complex governance transitions. He was the chief technical advisor and senior constitutional advisor to the Liberian Constitution Review Committee, where he supported the review and reform of Liberia's post-war constitutional framework. He has consulted for organizations such as Universal Strategic Group, Development Alternatives, advising the Ministry of Defense of the Republic of South Sudan on policy and strategic planning. Dr. Okot's professional life is defined by the rule of law. Among many other titles, that is Dr. Okot.
Good morning, everyone. That's too much information. That okay. As you know, PJ Otieno and Professor Pierre Lumumba. So I would rather we, the host, bit very short to the point. But just maybe a quick history. Maybe I say that on behalf of the board of trustees, we really welcome all of you. Let's have a very honest conversation about this legal empowerment for rural Africa. Many of you may recall that before the 2010 constitution, and I'm very proud that both my former teacher, PLO Lumumba, and myself actually midwifed two processes. You may remember the CCAT, the Review Commission, where PLO Lumumba played a similar role that I played in the committee of experts. And one thing I just want to remind you, maybe as part of the legal empowerment, that the so-called independence constitution that was written in Lancaster House Conference in London, Article 43 was not there. The focus was more on civil rights, so that the expanded Bill of Rights that we have today in Chapter 4 of our Constitution was missing in terms of all group rights, environmental rights,